The next part of the rules that we're going to talk about is all about the safekeeping of funds and other property. So here, this portion of the rules is going to make up 2 to 8% of your total NPRE exam. So the first rule that I want to discuss here is all about the safekeeping of funds and other client property. The rule says that when a client prepays a lawyer for services or otherwise gives the lawyer property, the lawyer must keep it separate from its own. It must not steal it, must not borrow it, or use it for their own personal advantage. So let's just stop there for a second. This means if you are in the habit of accepting retainer fees from your client, which is when your client prepays you and you basically bill for your services and expenses from that retainer, that is permissible. However, you need to keep that money separate from your own, and you cannot borrow it or ever treat it like your own money because it is not your money. You are holding it in trust for your client. It's also good to know that when your client prepays or gives you a large amount of money to hold on to, if they are giving you a large amount of money to hold on to, you should put your client's funds in a separate interest-bearing account with your client's name on it and allow them to keep and retain the interest earned on that money as their own. However, if your client gives you a small sum of money to hold on to, which is probably the average client giving their client, the average client will probably give their attorney a small sum of money to hold on to. Under these circumstances, that attorney can take that money and put it in a pooled client trust account. I say pooled because this means that the attorney is also holding other clients' small sum of funds in this account as well. And it is permissible to pool together different clients' funds in this trust account. Under these circumstances, if it's a small sum of money, any interest earned on this pooled trust account usually gets sent to the state bar or some sort of, charitable organization that the state bar has identified to receive that interest. So just taking a step back, let's go back over that. If your client gives you a large sum of money, you should make sure that that gets put in a separate trust account. So any interest earned on that large sum of money remains your client's. But if your client gives you a small sum of money, which is probably your average client, that sum of money can be pooled in a pooled client trust account where all of the interest earned on the client monies gets sent to the State Bar Association. Under the rules, it says that these client trust accounts must be held in the state where the lawyer practices, and if it's going to be held elsewhere, they need to seek permission to have these accounts held somewhere else. If you are in the habit of holding on to other property of your client, let's say like other physical property on behalf of your client, this property shall be identified as such and safeguarded appropriately. Complete records of such account funds and other property shall be kept by the attorney and shall be preserved for a period of 5 years after the termination of this relationship. When it comes to some general rule regarding client trust accounts, which we've already talked about a little bit here, it says that any money that a lawyer receives but has not yet earned, the lawyer must immediately put it in that client trust account and keep it separate from its own personal account or business account. So again, that's why we can pool our clients' monies together and keep it there or keep it in that separate account if it is a large sum of money until you've earned something. So that's the big takeaway. If you're holding money for your client up front, you can do that, but it needs to be kept separate from your own personal account or from the law firm's business account. Lawyers must not put any personal money or any law firm money into the client trust account because then that would be commingling of the assets, and that is not permissible. The only time that the lawyer can put its own money in this trust account or put law firm money in the trust account is for the sole purpose of paying bank charges that are, say, being charged by that financial institution, which is holding that trust account. However, the attorney should make sure that they are only putting enough information to cover those fees and charges as is necessary. Lawyers may only withdraw funds from these trust accounts as the fees are earned or expenses are incurred. If there's a disputed claim between a lawyer and a client as to how much money that lawyer has earned, what shall he do? The rule says if there's a dispute, the lawyer must keep the disputed portion in that client trust account until that dispute gets resolved. They should give back to the client what both the attorney and the client agrees is owed to the client, and the lawyer must pay himself what both the attorney and the client agree is the lawyer's. So let's walk through an example together. Let's say the lawyer places a $5,000 deposit in a trust account. Once the lawyer has completed her services, she sends a bill to the client for $2,000 and will turn over the rest of the money to the client. However, the client maintains that the lawyer's bill should only be $1,500, not $2,000. What should the lawyer do? Well, whenever there's a dispute like that, we've already learned that the amount in dispute should be held in trust. So first things first, the lawyer should give back to the client what both parties agree is the client's money. Here, that's $3,000. The lawyer should then pay him or herself whatever both parties agreed is the lawyer's. Here, the client has consented that the lawyer has earned at least $1,500. So the lawyer should pay themselves that $1,500. And then that final step is that the lawyer should hold in trust the amount of money in dispute. Here, that is $500. And the lawyer holds that in trust until the dispute is resolved. And then the last part of this rule that I want to touch upon is that the lawyer shall promptly notify the client or a third person who has, say, an interest in property or funds once that lawyer comes into possession of those properties or funds. And then lastly, the lawyer should render an accounting to the client upon request if there's any question about, say, the funds and expenses and fees incurred. That wraps up our safekeeping of funds and other property, and we're moving on into the next section.